The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Thorpe. Good afternoon and welcome to the North Carolina Court of Appeals. We have one case for oral argument this afternoon, State versus Shelly Ann Osborne. As you can see, your panel is myself, Linda McGee, Judge Dietz, and Judge Hampson. Are the parties ready to move forward?
Amicus is ready, Your Honor.
Thank you. We're here for the appellant.
I guess that's the question. Does that include the amicus?
Well, I think that was sort of the directive that we would have expected it to be, but yes, I think it does.
All right, thank you very much. If it please the court, David McDonald as amicus curiae appointed by the court, and I'd like to begin by thanking the court for giving me the opportunity to evaluate this important question. The issue of heroin overdose and drug overdoses is a critical problem, and I have to get off my chest that it affects all of us, and it has directly affected the judiciary of our Guilford County. And it's something that isn't relegated just to underprivileged classes or some undefined other people out there. And I view it as a social and economic and business and governmental issue, perhaps more than it is a criminal issue, but we're officers of the court and we have to work with what the legislature gives us. And so as long as it's a criminal matter, that's what we have to work with. Now, having gotten that off my chest, I do think that the question of an immunity here is an extremely important issue because there are so many instances where people experience drug overdoses and might be deterred in seeking medical attention to save lives without this immunity. And the legislature at least has provided this immunity. And I certainly believe that it ought to be implemented in a robust way. Now, the legislature has not gone very far in assisting the court in determining how it might be implemented. And I think that that's probably what Justice Earls was struggling with, is how do we put flesh and bones on this? Because it's really not there in the statute by itself. And I think that the place to begin is with statutory language itself. And it's really a limitation on prosecution. And that is a question of, well, how do you implement that? And there's a couple of issues, I think, that come into play. And in my brief, mostly I argued that it's a question of personal jurisdiction, like many immunities, like the immunity against a police officer. That's a matter of personal jurisdiction. And that was one of the questions that Justice Earls raised in her concurring opinion. And I think that the pathway to implementation of that goes pretty straightforwardly, that it's a question of personal jurisdiction, that personal jurisdiction is a matter that can be raised by a party at any point in the proceedings, even for the first time in the Supreme Court. And I added a suggestion of additional authority for North Carolina's General Statute 15A 952D, which specifically provides that questions of the jurisdiction of the court can be raised at any time and are not required to be raised in the trial court at any
Counsel,
time.
one question. First of all, let me thank you for, I heard you thank the court for taking on this role as court-assigned amicus, but I want to thank you. This is, I think, a really unusual situation for the court. A criminal case was in which there was court-appointed counsel for the defendant, remanded to this court with one of the justices of the Supreme Court identifying a potentially meritorious issue that would lead to a reversal of the conviction. And yet, because the appellate defender was unable to communicate with the client, was unable to confirm that representation could continue ethically, and I think led to a very difficult situation for the court, because we think this is an important issue. So for you to appear and make these arguments on behalf of the position of the defendant, I think is crucial for our ability to adjudicate it. So thank you for doing this, and all of this work, all of these briefs, of course, we're not being paid, and we recognize your service to the court. So thank you for that. But to get to my question, both personal jurisdiction and in general, what we just think of as immunities, so things like sovereign immunity, for example, are generally understood to be waivable by the party. So if you appear and don't make the personal jurisdiction argument, you can waive personal jurisdiction. And similarly, if you have an immunity, but you choose to appear, you can waive the immunity. And so I expect your friend for the state is going to argue that's essentially what has happened here. Is these are arguments that could have been made and just were never made, and so they're waived. And so one question I have, I think, is the heart of this issue. It's something that Justice Earls flagged, which is figuring out who has the burden of showing to this court that the statute actually applies. And I see it as there being just one key factual question that's unresolved, and that is the weight of the drug, because it has to be less than 1 gram. But we can't know from the record what that is. And so my question to you would be, looking at that statute, who in your view has the burden of making sure that's in the record for this court to waive this immunity?
Well, Your Honor, I believe that the statute is very clear about that, and it says that it's a limitation on the prosecution, and that the only way that it can be effectively implemented, I believe, Your Honor, is that it ought to be the burden of the prosecutor to show that in the face of a statute that says shall not be prosecuted, that they have to plead and show to the court that they in fact have standing. And I'd like to point out a case that was cited in the appellee's brief, and that is Urich against Schaefer. And in that case, the court observed that where a party does not have standing, then it's a question that the court itself does not have subject matter jurisdiction. And here, if the statute is interpreted, and I argue to the court and urge to the court that you do this, that because of the nature of the statute and what it says, that it excludes the prosecutor as an interested party, and therefore they have no standing to bring the criminal matter before the court at all. And if they want to have standing, they have to assert it and establish that.
So I imagine your friend for the state is going to say, well, the problem here is that when we take this the idea that it's immunity, or even that it's a sort of like a personal jurisdiction question, generally the burden would be on the party asserting, well, there is no jurisdiction, or the party saying, I am entitled to this immunity, to make sure that the evidence is there that can answer that question. And so even if the language says shall not be prosecuted, which seems to, I agree with you, it's a directive to the state, that the obligation to make sure the record has the information to apply that immunity would fall on the defendant here. And I think that's the reason I view this as such an important question is that if we think that it was the state's burden and the state hasn't met that burden, so the statute applies, I'm not sure that we would need to focus too much on this question of waivability here anyway, because we have Rule 2 in the Rules of Appellate Procedure, which provides that we can essentially waive the rules to prevent manifest injustice. And it's hard to think of a better example of a manifest injustice than when there's a statute that says that someone shall not be prosecuted for some act and was prosecuted for doing that. So what I'm focused on is who needed to show that question of the weight of the drugs. And I will add that if it turns out that it was the defendant, perhaps there's an MAR here for ineffective assistance for not having that in the record at some point. But so what's your, I guess my question would be, what was your response to, I think, an argument we're going to hear from the state that we should treat this like every other immunity, and because it just never came up, that's your, the defendant's fault, not your client, and therefore it's just been waived like any other immunity.
Well, let me first respond to that, Your Honor, by saying that my reading of the cases about immunities do not suggest that automatic or inadvertent waivers of immunity are favored. I suppose that it can happen in some circumstances, but if you're looking at something like sovereign immunity, it can only be waived by purchase of insurance. And that is done through an elaborate statutory framework. And certainly the legislature did not set out any framework in this statute to provide for waiver of this immunity. And I think that it's important, and I mentioned this in the brief, that I think it's important to recognize that there's an asymmetrical relationship between the court, the prosecutor, and a criminal defendant like Ms. Osborne in this case, that the resources available to both sides are disproportionate. And in that sense, and I don't think that's going to change anytime soon. And so in that sense, in terms of weighing how to implement this, placing the burden on a party who might not have the resources to meet the judge and to meet the prosecutor's office on an even footing before the court, I think that the court runs the risk of an issue of underutilization of a humanitarian gesture with that. And so therefore, I would suggest that this is a matter that this court might determine could be raised by any party and by the court at any time. That way, the court doesn't have to rely on Rule 2. I think that that 15A 952D provides support law for this being something that's not waived because it's not raised at before trial or even in the trial court. And I think that this court also could have an interest in preserving its own ability to do justice in a case when that's called for. It's an issue of, I think, economic disparity because it's not. I don't know the economic circumstances of Ms. Osborne, but typically I think the typical case here is a heroin addict or a person who's going to overdose on heroin is not going to be a leader in the community, and they're not going to have the resources of the legal community, and they're probably on hard times, and interfacing with the law is something that they're at a considerable disadvantage.
Yeah, I think again, I suspect the response from your friend for the state is going to be that, well, in a case like this one, though, where there was a right to counsel, there's a lawyer, and the lawyer, that's one of the expectations we would have for counsel in this situation is to make sure that in building a record, trial court, one of the things that's resolved is the weight of the drug so that we can assess whether, the trial court in this case could assess whether this bar to prosecution applied, this immunity. And so again, I think Stanley say this argument is one that's ineffective assistance, not something to be decided now on direct appeal when it was never raised. So what do we do about that? Other than I understand your core argument, which is shall not be prosecuted speaks for itself. The burden is on the state. But is there anything else when the state gets up here and says, look, it was up to defense counsel to get this in the record, that you can respond to that?
Well, yes, I would also say that based on what I've read in the state's brief, they really would like to demote this immunity to an affirmative defense. And I think that is placing the immunity in the same class as an affirmative defense if you don't raise it this way. And without taking into consideration, I think, a judicial reluctance to find inadvertent waivers of immunity, the courts don't have any problem finding inadvertent waivers of affirmative defenses. And I think that distinguishes these two, that the immunity is entitled to more dignity than an affirmative defense. And the state also suggests that the trial judge shouldn't have standing to raise the issue sua sponte. And I don't see support for that in the statute at all. So, and if the judges were alerted to it, maybe they might be able to ask the question. But at the same time, I think that the court can look at civil practice, which I'm much more familiar with than criminal practice. And in formulating a claim against a governmental entity, a plaintiff has not alleged a good cause of action against a governmental entity if they don't address the question of an immunity that has somehow been waived or doesn't apply. And a case is subject to dismissal on the basis of an improper pleading. And I just don't see that it's an unreasonable imposition upon a prosecutor where the statute itself says shall not be prosecuted, that to require in the face of a statute that they plead around the statute. And how hard is it for the prosecutor to say that in the indictment that the amount of heroin recovered was more than a gram and therefore the immunity doesn't apply? That's all they have to do, is plead around it just like a civil attorney would be required.
But we have an exceptional circumstance here where apparently the issue was not even recognized, and I can't say that that's any particular entity's shortcoming. I think part of the problem, of course, is just general knowledge about whether or not this opportunity is even available to people. It's a public awareness situation. But we've got a circumstance where no one, including any of us that were on the panel previously, saw that as something that we would even be aware of. And it didn't come up until there was a member of the Supreme Court that thought it was appropriate to share with us. It gives us an opportunity perhaps, but it also gives us a dilemma about exactly how do we try to cope with this in this particular circumstance, this particular case.
Your Honor, I share with you the concern about this, and I think the court does need to be sensitive to the rule that the court shouldn't make an appeal for someone. But at the same time, this is an immunity that appears on the face of the record. And if the court construes it as a question of the prosecutor's standing, then that goes to the subject jurisdiction, the subject matter jurisdiction of the court. And that's something that the court ought to look at. And certainly ought to be permitted to look at it at any time without regard to whether the parties have raised it. Because the court has an obligation to make sure that the laws are properly enforced.
And let me make your argument a slightly different way and see if you agree with me that this is the argument you're making. So we have all these waiver rules generally in our jurisprudence, but we also have this kind of odd exception that says the failure to the failure to follow a statutory mandate is never waiverable. So the failure to follow a statutory mandate can be raised for the first time on appeal. And although I've never seen the courts discuss it, I assume that's because the idea is otherwise, if the statute says you must do something and the parties just never bring that up, and so the court's not aware of it and does something different, the parties have essentially stipulated to what the law is by not raising some argument, and we don't allow parties to stipulate to the law, just to the facts. And so the court always has to say what the law is. And it seems like a similar thing here. If the law is that someone shall not be prosecuted for some act, and the record establishes that the statute applies, then we must look at that, whether it was, if it's raised on appeal and you haven't been court assigned to address this argument or raising it now, then we have to, as the court, address it. I take it that's your argument, essentially.
That's very, very close. Is perhaps more eloquently stated than I can do it. But yes, I think that the court does have a duty. And there was a Supreme Court case that I cited in my brief, and I don't have the name of it right before me, but it was a case where one of the U.S. Justices pointed out, I think it was Scalia, that just because the U.S. attorneys refuse to present a case to the court, it does not absolve the court of its responsibility to see to it that the law is properly applied. And I believe that was an immunity case. And I can pull that out of my brief if the court needs it, but I mentioned it and cited it in my brief. So I do think that the court has an obligation to look at it once it comes to the court's attention. And frankly, I believe, together with Judge McGee, that the fact that it escaped the attention of all of the parties here underscores how easy it is for this humanitarian gesture to escape the attention of parties in the court. And if it's going to escape the court and gets noticed for the first time in the Supreme Court, then we've got a problem with a statute that is underutilized and ought to be better utilized. And so it needs to have some effective mechanism to be raised even after trial. I'm trying to find it might be Mitchell against Forsyth, but it may be in Davis against U.S. I think may be the case where, in that opinion, the justice mentioned that the court really has a duty to look at an issue even if the district attorney does not bring it to the court's attention.
If I can jump in, Mr. McDonald. So we talk about what you could do post-trial to create to raise this issue. But, you know, of course, the immunity, if it isn't an immunity, the bar is from being even hauled into court at all, right? And so is there, you know, would there be an opportunity pre-trial to challenge the sufficiency of the indictment, for example? You file a motion to dismiss prior to trial on behalf of the defendant raising this issue. I guess in the civil context, it would be kind of analogous to a 12b2 motion to dismiss for lack of personal jurisdiction. You know, and I guess analogous to that, if you don't make a 12b2 motion, you least in the civil context, that's waived. So isn't there an opportunity early on here for a defendant prior to trial to make a motion to dismiss?
Well, certainly a defendant with knowledgeable counsel could do that. Now, another thing that I suggest is that if there's to be a question of waiver, it really ought to be knowing and intentional, just like the waiver of appointed counsel and waiver of arraignment and other things like this, so that the court could impose upon the court system itself a requirement just when Ms. Osborne presents herself to court, has the documents before her. Do you waive appointed counsel? Yes. Do you waive any immunities? And then the answer would be yes or no, but at least it would be in the record that there was in fact a knowing and intentional waiver. And that would be together with, it's not imposing a new procedure, it's just imposing a new line on a form that's already being used. And that does not seem like that's difficult at all. And would be a reasonable measure to ensure that if there were a waiver, it was knowing and intentional by the part of the defendant. It would solve that problem. I would like to reserve the balance of my time for rebuttal, if I may.
Certainly, Mr. Randolph. Thank you. We'll hear from the state.
Good afternoon, Your Honors. May it please the court. My name is Kristen Euchre. I'm an Assistant Attorney General with the North Carolina Department of Justice, and I represent the state in this matter. Jurisdiction and defense are not two sides of the same coin. Jurisdiction is more fundamental than an immunity. Immunity means a court has the ability to hear the case, but the person cannot be punished or sued. Jurisdiction, on the other hand, means the court does not have authority to hear the case at all. To illustrate, consider a person who commits a crime in South Carolina. That person is not immune from prosecution in North Carolina, but rather North Carolina does not have jurisdiction to hear the case. A person having immunity for a crime and a particular court lacking jurisdiction over that person's crime has the same result. The trial court cannot order the person punished for the crime. However, those two different premises are leading to the same conclusion. That doesn't make them the same. The same legislative silence that amicus asked this court to interpret as intention to make the immunity a non-waivable jurisdictional requirement is more accurately interpreted as an intention for the immunity to be implemented through existing pretrial procedures that must be initiated by the defendant. The first place you can look to see this is the plain language of the statute, which says shall not be prosecuted. It doesn't say the trial court can't enter judgment. It doesn't say the trial court or the judge or anything along those lines at all. It doesn't order the court to do anything or not do anything. It requires the prosecutor not to charge in those instances.
But isn't that kind of the point that really, the statute itself has pointed more towards that prosecution decision. And so we are reliant on the prosecutorial discretion to make the right choice whether to prosecute or not. And the question here is the prosecutor obviously made the choice to prosecute based on the facts before them. The question is, in light of that, if the prosecutor made the decision to charge incorrectly under the statute, how is that raised subsequently when the defendant is in fact called into court?
Your Honor, the statute itself contemplates that there will be disagreements about whether the immunity applies. Of course, the prosecutor is under an ethical obligation to follow all the statutes and rules that apply to the case. But in instances where the prosecution and the defendant disagree about whether he is immune, surely that is where the court is called on to act. And the legislature has already put into place a procedure whereby a defendant who claims he's immune can adjudicate that. And to go back to your earlier question, Your Honor, it can be made subject, the subject of a pretrial motion to dismiss. If you look at statute 15A 954, the legislature has already established that says the court on motion of the defendant must dismiss the charges stated in a criminal pleading if it determines that the defendant has been granted immunity from prosecution. So the General Assembly has already considered the concept of immunity, broadly speaking, in criminal prosecutions. And it has decided through the implementation of that statute that that is the way that it wants those claims to be litigated. The defendant is to raise a motion pre-trial, and the trial court can adjudicate those claims. The fact that there's nothing in section 90-96.2 setting up any different procedure simply illustrates that the General Assembly thought that the existing procedure was sufficient. As we know, the General Assembly is presumed to know the law in existence when it enacts new law.
So one of the issues here is we don't actually know whether the immunity would even apply based on the lack of evidence as to weight.
That's
right?
correct, Your Honor.
And obviously under the statute, that's not specific to weight. It's not necessarily an element of possession. So, if we're in a situation where motion to dismiss, has to be immune, okay, well, how much of substance does the defendant hold? State says, Your Honor, we don't know, we don't have to prove that. Isn't that sort of shifting now the burden of proof to the defendant to not only essentially, well, yes, Your Honor, I did in fact possess this illegal substance, and now I have to go in and prove exactly what the weight was. So already in this pretrial situation, you might be in a scenario where you're already shifting the burden of proof to the defendant before the state's even showing a shred of evidence, which I guess doesn't make it more defendant.
I'm sorry, Your Honor, it's a little bit difficult to understand you, but I think I got the gist of your question, which is that the burden is never being shifted to the defendant because the legislature has already allocated it to defendant through statute NCGS 90-113.1, where the legislature said it shall not be necessary for the state to negate any exemption or exception set forth in this article in any indictment. And it goes on to say the burden of proof of any such exemption or exception shall be upon the person claiming its benefit. That combined with 15 and 954, which says it, the immunity has to be brought up by the defendant, it's all quite clear that it is the defendant's duty to raise the issue and to show that he qualifies for the immunity. And I think did that answer your question, Judge Hampson?
Thank you.
Going back to the fact, the issue of whether it's jurisdictional, the mere fact that the statute is in mandatory terms does not make it a jurisdictional requirement. Our Supreme Court recently said that in State v. Bryce. And moreover, what you have in this crime of simple possession of heroin or any of the other crimes that are covered by the statute, those crimes are fully described by those statutes. This is not, the immunity is not an element of the offense. It's not something that is of a jurisdictional nature that the state has to allege in an indictment and then prove absent any sort of challenge from the defendant. And indeed, construing the immunity to be a jurisdictional requirement would have consequences far exceeding the humanitarian intent. To read it as a jurisdictional requirement would then require it to be on every indictment and arguably every indictment that has been returned since the immunity was enacted in 2013. So then you would have arguably jurisdictional flaws in every single simple possession that has been charged since then, even when the majority of those cases are not going to be involving a drug overdose.
Yeah, counsel, let me jump in because I think, and I didn't even hear your friend, the amicus, making the assertion that this is subject matter jurisdiction. So I think it's exceedingly unlikely the court is going to find that there's a subject matter jurisdiction problem here. But I want to go back to Judge Hampson's question because I too am struggling with, I don't see anything in this statute that discusses who has the burden of, and so the concern I have is that if what the legislature intended is for the state to be the one that has the burden to when the court is examining the issue of can this person be prosecuted on these facts, it's the state's burden to put in evidence, for example, of the weight of the drug to show that they have the right to proceed with this prosecution. And if that's the case, if we think that we have the ability now to take up this question under our laws about waiver and preparing a record and things like that, it would be the state's responsibility to have in the record the evidence of the weight of the drug. And if it's not there, then the defendant would prevail here. So what's your response to that silence in this statute about who has to show that each of the criteria applies for the immunity?
Again, Your Honor, 9096.2 does not specifically mention the procedure, but it is in the same article as 90-113.1, which that specifically allocates the burden of proof to the defendant. It simply wasn't necessary for the legislature to repeat itself when it had already said that the burden was on the defendant to show exemptions under the article. This is a burden of proof allocation that they've decided specifically for these types of crimes, that there are simply too many of them, I suppose, for the state to affirmatively negative, to use the oxymoron, to affirmatively negative all of those possibilities, and that instead that burden is on the defendant, who indeed is in the better position to know whether he or she qualifies for such an exemption or exception.
Well, I guess my question is slightly different, which is, I'm saying once the defendant raises the issue, I didn't read those statutes saying that it's the defendant's burden then to prove the drug amount. So you interpret that to mean once the defendant's raised the argument and said, I think the statute applies and bars this prosecution. Let's say it was timely raised and a motion dismissed. The state would say, well, fine, bring forward your evidence because we don't have to do anything. It's up to you to show that it applies, rather than saying the state at least has to present the evidence that they can move forward with the prosecution. That's your reading of the statute?
Yes, Your Honor. That is what it says. It says 90-113.1A, the second half of there says, and the burden of proof of any such exemption or exception shall be upon the person claiming its benefit. So yes, I guess you could almost divide this concept of burden into two different things: the burden of raising the issue, and then also the burden of producing the evidence and convincing the trier of fact. Judge Dietz, just to echo what you were saying during my friend's presentation, I think that the role of court-appointed counsel here is being completely overlooked. All defendants have a right to be represented by counsel, whether it's appointed or retained. So even the most disadvantaged defendant should have competent counsel representing him or her in the trial court, who should be aware of all of these provisions and defenses that are potentially available to those defendants. So simply to say that because people who are addicted to drugs are not as familiar with the law, that doesn't necessitate shifting the burden of proof, and indeed even the burden to raise this issue to the state, where the General Assembly has already allocated that burden to the defendant in these instances, and the issue of immunity, as well as the issue of particular exemptions from the North Carolina Controlled Substances Act.
Yeah, just to follow up on that, when we're emphasizing the fact that this could essentially could be seen as a mistake by counsel if we determine that it was the defendant's responsibility to establish the weight of the drugs so that we can assess whether or not the statute of immunity applies, then there would be an ineffective assistance of counsel claim here that could be made, asserting that it was definitely, the drugs were definitely not 1 gram or more. So had counsel raised that, there probably would have been a different result here, and therefore we've got a sort of a classic, Strickland test style ineffective assistance claim. So I assume the state's not disputing that could potentially happen here if we resolve this in the state's favor and direct appeal.
That's correct, Your Honor. These sorts of issues that are waived on appeal, often are then the subject of a motion for appropriate relief, and indeed that really is the more appropriate vehicle for this issue in this case at this point, because what has happened here is we have no idea if this was a strategic decision. We have no idea if the immunity even applies. It's simply impossible to tell if this was ineffective assistance from the record before this court. So if defendant did believe that she still does qualify for the immunity, she could certainly raise it through a motion for appropriate relief in the trial court, which is then equipped to take evidence and find facts to the extent those would be necessary. Along those same lines, that's the reason why this court need not go to the extraordinary length of exercising Rule 2 beyond all of the other layers of the state's argument, which is that it is not a jurisdictional requirement, that it is the defendant's burden of proof, and that this is, in fact, a waivable immunity. The same rationale from the Miller case relating to suppression motions applies here, which is that the state cannot be anticipating every potential issue that could be raised at any point and prophylactically creating a record. The record simply doesn't exist here to evaluate this claim, and it should be deemed waived on appeal. To that end, the state does want to respond to amicus's citation of 15A 952D.
Yeah, let me interrupt you real quick, counsel, and ask one more question before we move away from the ineffective assistance discussion, and that is, so you can imagine here the one thing about this case that feels somewhat unsatisfactory in saying, well, there will always be possibility of an MAR raising ineffective assistance of counsel, is that we know that the appellate defender, at least, was unable even to find the defendant, speak with her. It seems exceedingly unlikely that if this court were to issue an opinion, even one signaling that there was a potential ineffective assistance claim that could be pursued in an MAR, that MAR is going to get filed. And should we be concerned at all, sort of in the interest of justice, the unlikelihood of that happening, given the facts of this case? And for this, in the same way that we could invoke Rule 2 and hear on direct appeal an argument never raised concerning the statute itself, could we invoke Rule 2 and find an ineffective assistance claim here and remand to the trial court for a hearing? What's the state's position on that? I know it's been done from this court before by some judges who are not on this court anymore. I've never seen it from the current court as it's composed, but it's something you'll find in our case law, sending cases back for an evidentiary hearing rather than just dismissing to pursue an MAR. What's your response to that?
Your Honor, your question highlights what is a very, very unique circumstance of this case, which is that the defendant has never, ever, ever, ever asserted this claim, not even on appeal. So to say that it can be raised on appeal is putting the cart before the horse in this case. Your Honor is concerned for the question of whether the defendant would actually follow through with an MAR. I'm not in any position to hypothesize about that, and I don't know that that should really enter into the court's analysis of this legal issue, because simply put, it's the defendant's case. It's the defendant's has the decision to make here of whether she wants to pursue filing an MAR or if she wants to raise this issue on appeal. There's only so much that the court can do for her, and our Supreme Court has already stated that it's not the role of the appellate courts to create appeals for defendants. I think that it's this court's obligation to examine whether it had jurisdiction, and having resolved that issue, that the trial court had jurisdiction then accordingly this court and all the appellate courts that have considered the case also had jurisdiction. Anything beyond that would essentially amount to almost an advisory opinion.
One more question about ineffective assistance of counsel. So you're contending on the cold record that we could not find ineffective assistance of counsel here. Is that correct?
Yes, Your Honor. Because there's nothing, we can't even see that an error has been made. We cannot even tell that the immunity applies to this defendant. It's impossible to say that the trial attorney has made an error when we can't even tell if the defendant qualified for relief under this statute. And then additionally, on top of that, we don't know that failure to raise the claim was not a strategic decision for which counsel is given wide berth.
And how would it possibly be a strategic decision?
I don't know, Your Honor. I can't get into the trial attorney's brain and figure that out, but I can imagine that it could have involved calling the defendant to the stand, and perhaps they wouldn't have wanted to call the defendant to the stand for some reason. Just as something that comes to mind.
Thank you.
So shifting again to the waivable nature of this claim. Amicus is essentially asserting in his brief or his reply brief, I don't recall which, that because the legislature has not provided, has not specifically stated that this is a waivable immunity, that therefore it is not. That logic simply doesn't work here. By that logic, the legislature has to explicitly address any particular feature of the immunity in order for it to be a feature of the immunity, which would then foreclose Amicus's argument regarding jurisdiction, because the statute does not specifically say it's a jurisdictional requirement. And going to 15A 954 C's proclamation that the motion can be made at any time doesn't really add anything either. In short, that provision is just a codification of existing case law, which allows many of those motions to be made at any time, including in the instance of jurisdiction after conviction and upon appeal. And that is what, that is what the official commentary to that section says. It says that the General Assembly added subsection C to reinforce its deletion of motions under subsection A from the early filing requirement of GS 15A 952B, which 952B lists specific motions that have to be made at or before formal arraignment or at some other time prior to trial. So that phrase, at any time, simply means at any time pre-trial. And I think that is evident by looking at the rest of that list of motions that are in 954 that would then be able to be raised at any time, which our courts have long held cannot be raised for the first time on appeal, particularly constitutional issues such as double jeopardy violations and speedy trial violations. Those are constitutional claims which generally have to be raised for the first time in the trial court, not on appeal. The official commentary to 954 also says that being able to raise the jurisdictional claims at any time, even on appeal, continues the old rule, which is simply acknowledging that that is codification of existing common law, not creation of some new right or new procedure. The amicus's reliance on cases having to deal with sovereign immunity and other civil immunities are not on point on this issue, because not only are those civil liabilities civil immunities, which is an entirely different question of whether someone can be imprisoned. Whether someone can be sued for money damages is entirely different from whether someone can be imprisoned. Those immunities are largely common law created immunities. This immunity under 9096.2 is entirely created by the statute, and the legislature. So if the legislature has entirely created it, it can entirely regulate the procedure by which it's raised, and it has done so in 15A 954 A9, which deals with immunities in general, and then also in 90-113.1, which states that the burden is on the defendant to raise and to prove any exemption or exception. And I think that is perhaps where you can kind of see that it is somewhat different from a defense, because most things that are typically thought of as a defense cannot really be raised pre-trial. They're issues for the jury to consider. Here you have 15A 954 that has provided this pre-trial procedure for a judge to determine this issue before proceeding to trial. So it is elevating it in a sense above a defense. I did also want to touch on, amicus said that somehow requiring the defendant to raise the issue of immunity is demoting the immunity somehow. That's simply not true. I don't think that amicus would say that requiring the defendant to raise the issue of territorial jurisdiction is demoting the importance of jurisdiction, which our Supreme Court continues to say is something that must be challenged by the defendant in order for the state to be required to prove it. Moreover, there are other very important rights that are that must be raised by the defendant. For example, rights to be free from unreasonable search and seizure under the Fourth Amendment. Those are all claims that, if not raised in the trial court by the defendant, are waived, and even waived for plain error review, even if the appellate court thinks that maybe it can determine from the record. That's what the North Carolina Supreme Court said in Miller, that if the issue of suppression has not been raised, then the state has not been given the opportunity to develop the record fully, and it's not reviewable on appeal, even for plain error. And so again, that's another example of waiver of important rights by mere inaction, because you could have a defendant who could have a meritorious Fourth Amendment claim that he simply hasn't raised for who knows what reason, and then seeks to raise it on appeal. And our Supreme Court has said that he cannot do that, that his avenue for relief is a motion for appropriate relief in the trial court. And that's the same as the same avenue of relief available to defendant here. This issue simply has not been reserved for appellate review. The record is insufficient to address it, and defendant has never raised this issue and should not be granted relief on that basis. The state respectfully asks the court to affirm the judgment of the trial court. Thank you.
Thank you, Deepa. Rebuttal, Mr. McDonald?
Thank you very much. I'm afraid I might not have reserved enough time to respond, but I'll see what I can do to make as quick work of it as I can. The statutory procedures do not require questions of jurisdiction of the court to be raised as a matter of pretrial, and that's the Section D that was in the supplemental additional authorities. And I do think that the record in this case is deficient as to the weight. The prosecutor in this case did not establish that the amount of heroin exceeded the amount to justify this court in determining that the immunity doesn't apply. And I think even the state agrees that the burden of proof to establish the absence of immunity falls on the state. And here they did not do that based on this record. Now, with regard to Chapter 9113A, that statute speaks of exemptions and exceptions. It does not talk about immunities. And immunities are distinguishable in the law from exception. An exception in the law would be everybody who grows marijuana is guilty of a crime, except for those that do it under a government license. Now, that's an exception. And if there's a prosecution, then yes, to establish that exception, then you produce the license and you establish that. That's not the same.
And in fact, there are a bunch of exceptions, exactly like the one you just described, for example, for hemp and other things that actually are in our Controlled Substances Act, right?
That's correct. So an exception is not the same thing as an immunity, and it should not be lumped together. And I do not believe that 9113A is broad enough to include immunities. Now, Judge Deese, you raised a question, and that is whether it's a matter of personal jurisdiction or subject matter jurisdiction. And in the brief, I argue that it's a question of personal jurisdiction based on primarily federal practice. And that's the way they treat most of these things and analyze them in a civil matter under 12b-2. Our Supreme Court has not determined whether it's a question of subject matter jurisdiction or personal jurisdiction when you're dealing with immunity. While I did not put this in the brief, when I was preparing for this UREC case really actually addresses the question, and I apologize to the court for neglecting this, but the quote here is, "A lack of subject matter jurisdiction has been found where the petitioner lacked standing," and cites a case in Ray Miller. No subject matter jurisdiction because the DSS lacked standing to petition. Standing for an individual to bring an action for child custody is covered. So if the court should interpret this statute that says shall not be prosecuted as a withdrawal of standing by the prosecutor to raise a criminal prosecution, then I think that does establish that the court does not have subject matter jurisdiction. So I think that's a fair issue before the court, and in fashioning basically the response that Justice Earl asked for, I think that there is at least that pathway as well, that it could be subject matter jurisdiction, it could be personal jurisdiction. Those are both clearly results that could be reached by this court in analyzing this. The purpose of immunity and the purpose of many immunities is, and particularly immunity like this one that is against prosecution, is not served by making it something that places burdens on the defendant. The whole calculation, I think, behind this immunity is that a person faced with an overdose is not going to be burdened with the concern that if I call EMS, 911, the doctor, seek help for my friend here who's dying or I'm dying, that they're going to have to incur some kind of criminal liability. That's the whole purpose of it. And to place burdens on the defendant and to treat it like an affirmative defense or something of that nature just completely eviscerates the purpose of this immunity. Is to not be prosecuted. It's not to give the defense once the prosecution is underway. So I think that the last point I'd like to make is that one issue that Ms. Euchre raised about this is that by placing it as an affirmative defense and having the defendant be the one who has to raise it conflicts with a criminal defendant's Fifth Amendment privilege against self-incrimination. If she's got to get up and say, I didn't have a gram of heroin there, it was less than that, that's a different kind of calculation, and it places her in and her attorney in the position where she has to weigh whether she's going to have the benefit of the immunity or have the benefit of the privilege. And I think that that's unfair to place them upon a position, a person in that position like Ms. Osborne.
Thank you, Mr. McDonald.
Thank you very much, Your Honor, and it's been my privilege to address this question.
Well, we appreciate both of your arguments, and we particularly appreciate your service in this way to the court. Thank you.
Thank you very much.
Mr. Soar, would you please adjourn court?
This session of the North Carolina Court of Appeals is now adjourned.